Well, why don't we get going, everybody? Welcome, everyone, to our 7th webinar in the Restart Hawaii series. You know, our series is designed to help people start new businesses, especially those that may have lost their businesses during the pandemic, but just anyone who wants to start a new business, we are trying to share with you and convey information and forms that could help you get going and minimize any legal costs that you might have. And so we're trying to stay focused on real practical aspects of doing this. Our next webinar is actually next week. We have a bonus webinar being put on by the William S. Richardson School of Law. And it's basically going to be an overview webinar of all the topics discussed in the series. And so I would encourage you to attend that. You will receive a Zoom link for that one. But originally it was an open date. And so that'll be a bonus. And the week after we end with the webinar relating to finding a space for your business and getting a lease done. Want you to know that we're recording this session as all sessions. So if you don't want to be seen or you don't want to be heard, you need to turn your video and or audio, well, make sure your audio is off, but certainly video you'd want to turn off. The recordings will be published eventually, but we're not sure exactly when, sometime after April. So it might take us a few months to edit, polish them up, and then publish them. So we're glad you could be here to see it live. I'd like to introduce my colleague and partner, Kat Tashner, who's a co-founder of Business Law Corps, to give you a brief overview of what we do at Business Law Corps. So Kat.
Hello, good morning, everybody. Thank you for attending today's webinar. It's hosted by the Business Law Corps. We're a nonprofit organization that provides free legal services to small businesses and entrepreneurs throughout the state of Hawaii. So please keep us in mind as a resource as you start and grow your company. Our website is under construction, but I wanted to share with you a few resources. I think one that might be relevant to you guys is you go to our homepage, we have a lot of downloadable forms that you might want to take a look at. So let's see, take a look at these. You can visit our Dropbox. Another resource that I wanted to share with you is that we do free 30-minute legal consultations every week, every Wednesday. And so I'll drop links in the chat box that you can find out how to sign up for those appointments. But I think if you have any questions after today's seminar, that's a good resource to keep in mind. Throughout today's seminar, if you have any questions, please feel free to DM them to Greg or to myself, or feel free to just drop it into the chat box and we'll raise them to Chris once he's done with his presentation. So thanks again for attending today.
Thanks, Kat. I want to also thank our interns, Stefanos and Christian, who've been helping us with the flyers, with the series itself. So thanks for all of your time and help. And as Kat mentioned, we'll leave about 15 minutes at the end for questions. Chris has kindly offered to stay online a few minutes after 11 to answer any other questions that you may have. So if you want to stay on at the end, you're welcome to. And without further ado, I'd like you to meet Chris Ye. I've known Chris for a long time actually now. Gosh, I hate to even get into that, but we were partners together at Goodsell Anderson for a while and had a lot of fun together. Chris is a good guy. He's well-educated, Harvard University and Harvard Law School, but he practices labor law and employment law. And I would just say that anytime I have a employment matter that requires, someone good, I definitely go to Chris first. He's my go-to guy. And so I highly recommend him as an employment lawyer. And I think they practice mostly on the company side. So if you have a business startup, he could help your company with respect to employees. And, I'm going to post his bio in the chat so you can look him up. And with that, I want to thank Chris for doing this webinar, and I'll turn it over to Chris, and he's going to share his materials. I will share the materials via Dropbox link in about 20 minutes. So you'll be able to download it. But for now, he'll just walk you through it. So Chris, can you take it away?
Okay, thanks very much, Greg, for that kind introduction. And I appreciate the opportunity to participate in this series and to help out how I can. So I'm going to share, if I do this correctly, my materials here. Hopefully that is now visible. And so my topic, as Greg has mentioned, relates to employment issues, particularly at the initial stages. If you're looking to start your business and bring on personnel, what are some of the things that you need to be thinking about? And there's a main focus here about employees and independent contractors. And of course, at the very outset, when you're bringing someone on, you need to make that initial decision. Well, are they an employee or are they an independent contractor? And what I see sometimes, and I've been representing employers for quite a few years now, is there is a tendency to want to call personnel independent contractors, and that almost becomes the default, but it actually should be the opposite. The default should be, you should assume that they're employees unless you are really comfortable after doing the analysis that they are independent contractors. And the reason for that, we'll scroll down here. As it says here, if you are considering having a person be an independent contractor, you want to carefully analyze whether they truly qualify, because the penalties and liabilities for misclassification are potentially severe. So let's say you've got someone and you call them an independent contractor, but in actuality, meaning as ultimately determined by an agency or the courts, they should be an employee, right? So now you've misclassified them, you treat them for months or even longer, years, as an independent contractor. What that means is you're not keeping track of time and payroll records. You're not making sure you're paying them minimum wage and overtime. You're not providing them with benefits like work comp or TDI or prepaid health insurance under the Prepaid Health Care Act law of Hawaii, or logging them for unemployment insurance contributions that you have to make quarterly to the state. You're not doing any of those because you're assuming that they're an independent contractor. But let's say through some type of complaint or audit, they're determined to be an employee, then your liability, depending upon the investigated area, could be in a lot of different ways. For example, you could be liable for not paying them overtime or not paying them minimum wage. And under the wage laws, you could have to pay liquidated damages, which is double the amount that you owe them. You could be liable for paying their out-of-pocket healthcare costs since you did not provide them with healthcare insurance. And you could be liable for, because you didn't provide them with work comp and TDI, the Hawaii legislature actually amended the daily penalties to make them way more severe. So for example here, as an example, the work comp law now says that if an employer fails to provide the required work comp coverage, it should be liable for a penalty of not less than $500 or $100 for each employee for every day of the failure. So imagine if you got 5 misclassified personnel, in one day, that's a $500 penalty. In 1 week, that's a $2,500 penalty, and it really adds up. Now, I think as a practical matter, Department of Labor is not going to, slam most companies for thousands and thousands of dollars if the company can show sort of a good faith error. But theoretically, it's possible. So you really want to be careful to make sure you get that initial classification correct. So the tip here is, before classifying someone as an independent contractor, just make sure you give it some real thought as to whether they truly qualify. And you should assume they're an employee unless you determine otherwise. So what are the tests for independent contractor status? Under Hawaii law, there are various tests depending upon which Hawaii benefits law you're looking at. But one test that appears under a couple of the Hawaii benefits laws is called the ABC test. And the reason it's called ABC is because there's 3 parts. There's an A, there's a B, and there's a C. The important thing is you have to satisfy all 3, not just one of the 3, you have to satisfy all 3 in order for that person to qualify as an independent contractor under those particular Hawaii laws. So part A is that the individual essentially is free from control, meaning you don't direct them, you don't supervise them, you don't evaluate them, you don't tell them what to do, when to do it, or how to do it. They're free from your control. Part B, you need to satisfy either or of these. Either their work is outside your usual course of business, or their work is outside all of the places of your business. Now, keep in mind that the Hawaii Department of Labor has, at least informally, indicated that they interpret places of business pretty broadly. And I think actually even in the regulations, it describes places of business as all territories in which the company operates. So it may be pretty hard to satisfy that outside all the places of business test. It may be a little easier to satisfy outside the usual course of your business. And then part C is that the individual is customarily engaged in an independent trade of the same nature as the services they're performing for you. So if someone is providing janitorial services for your company, you want to make sure that they actually have an established janitorial business with their own GE license and employer tax ID number, and they're doing it for a bunch of different companies, and not just one guy who's only providing janitorial services for your company, which is going to start to sound a lot like your employee, your janitorial employee. You don't want that. You want that to be an independently established janitorial business that's out there advertising and doing the same service for a whole bunch of different companies around the island or around the state. So here's just a couple of simple examples. Let's say a retail company retains an information technology specialist, an IT person, to run your computer system. You do not direct the specialist. You don't tell them how or when to do the work. In fact, you can't because you don't have that knowledge. They're not a part of your usual course of business. Let's say you're a retail company, and of course your business is not you're not in the business of providing IT services. So this IT person is outside the usual course of your business. And they have their own incorporated business, and they provide IT services for a whole bunch of companies around the state. So under the ABC test, that person or that company, I think, is more likely to be an independent contractor. On the other hand, let's take this other example. Let's say you have a retail company and you retain a consultant. And I see this from time to time where a company will say, oh, we have a consultant and they're an independent contractor. I get a little nervous with the term consultant because what are they consulting you on? Are they consulting you on kind of your core operations? If this consultant is overseeing your retail operations, even though they have general discretion and even though they have their own business and are doing it for other companies, it may not be the case that they are outside your normal course of business. They are in fact directly involved in consulting on or overseeing your normal course of business, which is retail. So in that case, that person may not actually be an independent contractor. Again, I use that example because I have seen cases where they're called a consultant and there's just an assumption that if they're a consultant, they're a contractor, and that's not actually the case. The label doesn't really matter so much. You have to look at the actual function, and in this case, the ABC test. So under a couple of other Hawaii laws, like the work comp law and the TDI law, the tests that they use to determine an independent contractor are the following, and they will apply both of these tests. The control test, which is kind of, again, goes back to you don't control that particular person. You don't tell them what to do, how to do, or how to do it. They just have a general directive of maintain your IT system. And the relative nature of the work test, which generally means they are kind of on their own, doing their own business. It's not a core part of your business, and kind of relates to the ABC test, right? They're in business for themselves and they're providing this service for other entities. So there's some overlap of the two types of tests. So the tip here is before you call someone an independent contractor, you want to ensure at the very least, all right, these 3 points, which kind of correspond with the ABC test, that you do not have any actual or even theoretical control over their work, right? You don't want to have some document say that we reserve the right to supervise and direct you. You don't want to have it theoretically, you don't want to have it actually. You can just generally make sure the work is being done, of course. You can make sure the IT person is maintaining your system, but beyond that, you don't want to be getting into details or micromanaging. Second, you want to make sure that their work is not part of your usual services or is not performed at any of your places of business. As I mentioned, usually the first part of that is going to be easier to satisfy than the second, meaning showing that their work is not a usual part of your business. And then the third is that they have a separate license with their own ID number and that they're actually doing this for a bunch of companies around the state. Okay, here are some other important points that will help show independent contractor status. You do not provide them with any training or equipment or reimbursement, right? Those are the kinds of things you do for your employee. You bring on a new hire, you train them, you give them the tools, you give them a computer, give them a laptop, you reimburse them for their expenses when they have to go to meetings. You do that for your employee, you don't do that for a contractor. You do not want to require the work is done by only one particular individual in the case where the contractor is a business entity. If you're just requiring the one same guy, Fred, to do all the janitorial services, it's going to start to sound like Fred is your employee, not a contractor. You do not provide any employment benefits. You don't give Fred vacation or sick leave or PTO. When you pay the contractor, you pay them as 1099. You, of course, don't want to be applying payroll taxes. You don't want to be applying FICA and FUTA taxes to that. And the idea is the contractor can make a profit or loss depending upon how they run their services. So if they can be really efficient, minimize their own expenses that they're responsible for paying for, get the job done, then they make more money. That's fine. You don't care about that. You just need them to perform the overall task. Okay, so what are some types of language that you might want to use in a contract? So this is sample language. Obviously, you'll want to tailor it for your particular situation. It's not necessarily a one-size-fits-all. But just this general template can be a helpful starting point. So you'll want to define, of course, who the parties are. It's going to be your company and it's going to be the contractor. And I think it's helpful to identify and memorialize their general excise license number. Then you'll have it documented and it'll confirm that, yes, at the outset of the relationship, they already have that GE license. Then you can describe the duration of the contract. If you're able to make it for a finite duration, like 6 months or a year, that will help show it's an independent contractor relationship as opposed to an indefinite employment relationship. But identify some particular period of time, ideally. You'll want to describe what the services are. You'll want to say under section 2B and C, essentially it's a non-exclusive relationship, right? With your employees, typically they're working only for you, and you're giving them full-time employment. In the case of an independent contractor, you can use other contractors if you want. It's not exclusive. And they, of course, can and should be providing their services to other companies. You don't want them providing it only to you because that's going to start to sound like an employment relationship. So you want to make sure you recognize that everyone has the right to do, to have the relationships with others. You are allowed under D to require them to keep accurate records in case somehow you need some kind of proof of the work that's done. You want to make sure under E that they're not authorized to transact any business on your behalf. So they shouldn't be, you don't want to give them business cards, right? Because they're not your employees and you don't want them going out there representing that they're representing you or that they can enter into agreements on your behalf. They're really an independent contractor. Under F, you can require them to just do a good job generally, right? To act in good faith and to act in a reasonable, prompt manner. That's not micromanaging. That's just saying, you're going to be diligent about what you do. Under section 3, you want to provide and describe the way payments are going to be made. And the main idea there is it's going to be 1099 payments, not payroll checks. So the relationship of the parties under section 4, you want to have some explicit statement that it's an independent contractor relationship. Under subsection B, that's where you say you're not going to exercise any control over them. Under subsection C, if it's factually applicable, you'll say that they're doing the work off the premises of the company. But if that's not applicable, if it's the IT guy coming into your establishment, then of course you would not have that sentence. Under section D, it just confirms that they can work whatever hours they wish, within reason. I mean, if you have business hours, they can only come onto the premises during business hours, but you're not going to tell them you can only be here between 8 and 9 on Mondays, right? That's too narrow. E establishes that they're not going to be reimbursed, right? All the expenses they incur on their own as an independent business. F tells them they're not getting any vacation or sick pay or any other employment type of benefits. G says, confirms that they're a licensed and experienced professional and they do not need any training. Section 5 basically says that whatever the contractor wants to do in terms of hiring personnel, employees, whatever, that's entirely up to them. They're entirely responsible for all the expenses of hiring and training their own personnel, and none of that is attributable to your company. That's essentially what Section 5 states. Section 6 just deals with indemnification and liability. So for example, if the contractor engages in some alleged misconduct and someone wants to sue the contractor and also wants to sue your company, you kind of get thrown into the mix. The idea here is that the contractor will defend and indemnify you, meaning cover your liability and losses in the event that you get sued because of their conduct. Under Section 7, it talks about how to terminate, and you can provide for termination on whatever terms you want. Typically, some kind of written notice, 14 days, 30 days written notice by either party to the other. You don't want to be locked into a permanent relationship. And sometimes these agreements will say that if either party breaches the agreement, like they're just not performing, you're not paying them, or they're not performing the services, you can terminate more immediately upon written notice. So the tips here are, of course, you can use this type of template language, but make sure you tailor it to your particular situation. Once you have an independent contractor agreement, you still want to make sure you follow it and actually treat the person or personnel as a contractor. Merely having the agreement or merely calling them a contractor does not guarantee that they truly are a contractor. And I see that happen with some regularity, that people think, oh, just because we both agree that they're a contractor, it's no problem. It's helpful to have the agreement, but I've also seen situations where at the outset, when the relationship is pretty rosy, everyone agrees there's a contractor. Down the road, the relationship goes south, and that person is now saying, hey, wait a minute, I'm actually an employee, and now you owe me overtime and all this insurance and benefits and everything else. So merely having that agreement at the beginning is not enough. That person still has the right and the ability to make a claim that they should have been treated as an employee, and you want to have all the facts in your favor, including this agreement, and also the facts showing that you follow the agreement to defend yourself if a claim or an audit is brought up. Okay, so now let's talk about employees. Let's say you've determined, no, these are not contractors, they're going to be employees. What are some things to keep in mind? Well, those employees generally are at will. That is the default. So if you just basically hire someone, they're at will, which basically means either you or they can end the employment relationship at any time for any reason. Good reason, bad reason, no reason. So if you're a Celtics fan and you find out that the person you hired is a Lakers fan and you're going to fire them for that, that's not a good business reason, but it technically is legal because they're an at-will employee. You can fire them for any reason. However, there are limitations on that. If you have a contract with them that guarantees them some job protection or a duration of employment, then they're no longer at will. For union employees, if there's a collective bargaining agreement that says they can only be fired for just cause, they're no longer at will. And also under federal and state law, there's a whole bunch of protected classes that you cannot rely upon in making an employment decision. So I've listed some of the protected classes here. And again, these are either under federal law or Hawaii law. Hawaii, being a more liberal state, is going to have more protected classes under state law than more conservative states. But protected classes for a Hawaii employer generally include things like race. Obviously, everyone has a race. Color, which is literally the color of one's skin. Religion, whatever the religion is, Christian, Buddhist, Muslim, Hindu, atheist, agnostic, those are all protected. Sex, including pregnancy. National origin, which is where an employee's country of birth or where their ancestors came from. Age, whether they're young or old, because under Hawaii law, there's also protection for being young. Ancestry, again, which is where one's ancestors are from. Disability, sexual orientation of any type. military or veteran status, marital status, being married or single, genetic information, genetic history like family history of cancer, arrest or court record, credit history, gender identity or expression, being a victim of domestic or sexual violence, reproductive health decisions such as making a decision to lawfully terminate a pregnancy, and citizenship. So all of those are protected, and you as the employer cannot make any employment decision, generally speaking, based upon those protected categories. Unless you want to purposely override their at-will status, which again, you could do if you want to do it on purpose by entering into an agreement, but unless you want to do that, you should be careful not to make any representations or promises that might suggest a guaranteed or fixed duration of employment. So for example, if you just kind of say, or put in an email, oh yeah, don't worry, you'll be around to get your year-end bonus, and you're saying that in January, the employee could say, hey, yeah, they made me a promise that I was going to be employed for the full year, that I would be around for my bonus in December or at the start of the next calendar year. And so I'm no longer at will, I've got a guaranteed year of employment. So you really want to be careful about making those kinds of statements. What you want to do to protect against that is to have some kind of a handbook and handbook acknowledgement that will include express statements that confirm their understanding of an at-will relationship, and that no contract can arise unless it's in writing and signed by the appropriate company personnel, like president, manager, HR, whomever. So here's sample language that you can use. Employment with a company is at will. This means either you or the company can terminate your relationship at any time for any reason without notice. No person other than the fill in the blank is authorized to enter into any employment agreement on behalf of the company, and any such contract must be in writing and signed by the company to be effective. That way, the employee cannot say, oh, I got an email from a supervisor and I think that's a contract. No can, because you have this written acknowledgement that any contract must be in writing and signed by the company president or whomever is designated. In terms of supervising your employees, unlike with a contractor whom you do not want to supervise, you can and you should regularly supervise your employees to make sure that they are following the rules and doing a good job. It is also typical to have a set of workplace expectations. Sometimes companies call it house rules or a code of conduct, to advise the employees what type of behavior is prohibited that can lead to discipline up to and including termination. Now, you don't have to have this in writing in order to terminate an employee for bad conduct, but it's always better. It seems fairer if you've given the employee notice of that. So some things, that types of conduct that typically appear in the house rules or the code of conduct, you'll say that the employee can be disciplined up to termination for their failure to perform duties, violations of safety rules, falsification, including on applications. Let's say you later discover a year into an employment relationship that they falsified their application in a serious way, you can fire them for that. Fighting or threats or aggressive behavior, stealing, insubordination, use of or being under the influence of alcohol or illegal substances, unexcused absences or tardiness, sleeping, or discriminatory or harassing conduct. But you want to make sure when you list those, you say it's a non-exhaustive list, because you want to preserve the right to discipline for other reasons that you haven't thought of, because mischief can come in all kinds of unexpected ways. So the tip here is to have an employee handbook, or at least a set of policies that you can give in writing, have the employee sign an acknowledgement, including the at-will disclaimer that I described, and also including a set of house rules that I've described. And you might want to tailor it for your particular industry, but I think it's very important to get that out there, have the employees sign their acknowledgement, understanding of at-will employment and the house rules. Now, let's talk a little bit about some types of employment contracts that you might want to have with employees. You don't have to, and you might decide that it's not a good idea to have any of them, but you could consider it. So here are the types of agreements that you might want to have. One is an arbitration agreement, which is an agreement that you and the company mutually decide to arbitrate any work-related disputes rather than having to go to court. And the reason you might want to have that is because, generally speaking, arbitration is cheaper, faster, more confidential, a little bit more informal, and therefore less stressful than having to go to court and have a big trial with a judge or with a jury. So that's the reason you might want to consider having an arbitration agreement. It funnels everything to a private arbitration rather than a trial. Confidentiality agreement basically tells the employee that they will agree to maintain the confidentiality of your sensitive company information. So for example, that could include your operational methodologies, your marketing strategies, any kind of trade secret type of information, your customer lists, if that is in fact confidential, client contact information, all that kind of stuff. You have the employee agree that they're going to keep all that information confidential. Keep in mind though that under Hawaii law, fairly recent Hawaii law, wage information is not confidential. So you cannot and should not require your employee to maintain confidentiality of wage information. They do have the legal right to discuss that wage information. And then the third type of agreement you might want to consider is a non-solicitation agreement, which basically says after they leave your company, they will not solicit your employees or your customers to go elsewhere. So generally, it's a good idea to have that if you think this employee would be in a position after leaving to effectively solicit your employees or your customers. Now, the reason you want to have these in a contract is really to regulate what happens after the employee leaves your company. When the employee is with your company and you find that they're violating confidentiality or they're soliciting employees or customers to go elsewhere, you have an enforcement mechanism against them, which is that you can fire them or discipline them because they're still your employee, right? That's obviously inappropriate behavior and they're fired for it. But once they leave your company, you no longer have that enforcement power. So really the most effective way to enforce it against them is to have had them enter into a confidentiality agreement or a non-solicitation agreement during their employment, and then you can enforce that against them after they leave your company. Now, keep in mind that to be valid, these types of agreements have to have some type of consideration. Consideration means you've given something of value, right? They're giving something of value to you, which is their promise to maintain confidentiality or their promise to not solicit. You have to give them something of value, and it's generally easier to do it at the start of employment because what you're really giving them of value is hiring them. Their employment is what you're giving them, and that's obvious consideration. Now, if this is an employee that you've already hired, you can't give them consideration of hiring them because that's already been done. So you'll have to figure out something else of value to give them if you want them to sign onto any of these types of agreements. So here's some sample language to consider. So let's look at the confidentiality one. During and after employment, they will not disclose, use, or allow the use of any confidential information. And then you can describe the confidential information in whatever manner is appropriate for your particular company. Make sure you don't include wage information. And you also indicate that the employee agrees to return all company property and confidential information at the end of their employment. So if they don't do that, you can, among other things, sue them for a breach of this contract, this confidentiality agreement. For the non-solicitation provision, you will say during and after employment. Sometimes companies will put a duration on this, but you don't have to. It can just be kind of an ongoing indefinite duration. The employee agrees to not solicit or encourage any of your customers to go elsewhere, to go to a competitor, and agrees not to solicit or encourage any of your employees to quit the company. And there's an agreement that this can be enforced in court. And also it says here that the employee agrees to disclose the confidentiality and non-solicitation provisions to any subsequent employer. Because if the subsequent employer doesn't know about it, they may innocently say, oh yeah, go ahead and try to solicit clients from your former company. But if they are aware of it and they're very conscientious, they're gonna tell their new employee, don't do that because you're subject to this agreement. We don't want to be dragged into that. So don't solicit any of your former clients. The arbitration provision, I'm not going to walk through this in detail because it gets a little technical, but the general idea here is a mutual agreement by the company and the employee to funnel all disputes that otherwise could be in court instead to go into arbitration. The issue of who pays for the arbitrator fees comes up, and the important thing to keep in mind is an employee cannot be required to pay the arbitration fees if it would be prohibitively expensive. So if it is prohibitively expensive, they should be excused from that. But if they can pay it, then it can just be a 50-50 split. So that's the arbitration provision. Again, there's a lot of legal language in there, but I'm not going to walk through that right now. I do want to talk briefly about another type of agreement called a non-compete agreement. Companies will use that. The reason I don't give language here is because there tends to be a lot of litigation or legal dispute when a company tries to enforce a non-compete agreement against a departing or former employee. So just what you want to be careful about is that courts will not enforce a non-compete agreement if it determines that it's not reasonable. Reasonableness is usually measured in terms of three things. Number one, what is the former employee being restricted from doing? Typically, it says you cannot engage in a competing service. Second is, what is the geographic scope? And the narrower you make it, the more reasonable it will be and the greater enforcement there will be. So if you limit it to, not the whole country, I mean, state of Hawaii, even better, even narrower would be the island of Oahu, even narrower would be within X miles of your business. The narrower you can make it, the more likely it will be enforceable. And then the third one, which is the big one, is the duration of the non-compete. If you make it too long, you're going to risk non-enforcement. 2 years generally at the longest. If you can make it shorter than that, that would be safer. A year, 6 months, something like that. So the tip here is decide prior to hiring your personnel whether you want them to sign any covenants such as confidentiality, non-solicitation, arbitration, or non-compete. If so, have them sign it at the time of hire and as a condition of hire so that it's clear that you've provided them consideration to make those agreements valid. All right, and then the last sort of big section here is that you'll want to have some anti-discrimination policies. Things to keep in mind are discrimination, harassment, and retaliation. Generally, what the concept means is discrimination is taking an employment action because of an employee's protected class. So remember that long list that we talked about earlier: race, color, age, religion, sex, disability, marital status, national origin, all those kinds of things. You should not be making any employment decisions based upon those. For example, you can't refuse to hire someone because of their race. You can't terminate someone after you learn of their religion, and you can't refuse to promote someone because of their gender or their age. Harassment is a type of discrimination, and it generally means unwelcome conduct that is based on a protected class. So harassment is usually not, I'm going to fire you. That's discrimination. Harassment tends to be more atmospheric. So comments, insults, jokes, touching, visual displays, offensive emails, all of those kinds of things can constitute harassment if it is based on a protected class. So I'll just note, if you have a manager who's a jerk to everyone, that's not a good business practice, but technically that's not a violation of the law because it's not based on a protected class. It becomes harassment in a hostile work environment when it's discriminatory and it rises to a certain level of being severe or pervasive enough to create an intimidating, hostile, or abusive work environment. So one joke by itself, not good, but probably not a violation of law. But if it becomes an accumulation of jokes or insults, that's going to become a violation of law. Retaliation means punishing an applicant or an employee because they've made a protected complaint. So if an employee goes to HR and says, hey, I think my manager is discriminating against me, and the manager gets all mad and says, hey, why are they complaining about me? I'm gonna demote them. That would be retaliation in violation of the law. So essentially, you want to have policies that prevent discrimination, harassment, and retaliation. You want to have employees know that they can and should report that immediately so that it doesn't snowball and become much worse. Having such policies will prevent the likelihood of bad conduct. It'll help maintain morale, and it'll help prevent good employees from leaving if they feel that they've been discriminated against or retaliated against. So here's some sample language. I won't go into this in too much detail, but this paragraph essentially says that your company is committed to non-discrimination and will not tolerate any discrimination or harassment based upon the laundry list of protected classes. It says here that the conduct may violate this policy if it is offensive, unwanted, or undesirable, and that employees should be very careful because what someone perceives as unwelcome, you don't always know, so you want to steer far away from that, from crossing that line. You'll want to indicate that the company equipment should be used in accordance with this policy. So of course, if your employees cannot verbally make those insults, those racial insults, of course they can't use your computer system and your email system to communicate those insults. Then there's particular language and attention given to sexual harassment here. And this comes from the EEOC, Equal Employment Opportunity Commission regulations. And I think that's because sexual harassment has historically been one of the major types of harassment. I'd say sexual harassment and racial harassment have been historically the most common types of harassment. So this just provides a little bit more description of inappropriate and prohibited sexual harassment. It should not be, for example, here of involve inappropriate physical contact. It should not be verbal, and it should not involve visual displays or gestures. And then this part is important. If an employee feels that they've been subjected to or witnessed the conduct, they should make a complaint. And you'll want to identify at least 2 positions or persons that they can complain to, because if the person they believe is perpetrating the harassment is that one person they complain to, then they'll say, I have no avenue to complain. So you want to give at least 2 people. It doesn't have to be the manager and the HR manager, but typically it's going to be those types of positions. You want to make sure that whoever is identified or whatever position is identified is aware that they've been identified, and that if they get a complaint, they know what to do, which at the very least should be involving human resources and coordinating some kind of review or investigation of the alleged misconduct. That's very important. Then here, you tell them not to wait to report it immediately so that you can kind of stop it before it becomes a violation of law. Okay, in terms of the investigation, you'll want your policy to say that you will investigate this in a reasonably prompt manner. You may not be able to get it done in 6 hours, but you should investigate in a reasonably prompt manner and in a reasonably confidential manner. Now, you cannot guarantee complete confidentiality because you're going to have to go to the alleged harasser and advise them of the allegations to give them a fair chance to respond. But you will do it in a reasonably confidential manner. You're not going to tell people who are outside the need-to-know circle. And you'll want to indicate, this is important, that the company prohibits retaliation against any individual because they've made a complaint or participated in the investigation process. And you want to let people know that any violation can result in discipline up to termination of employment. And when you have all this information, this will help your business. Because number one, if employees actually pay attention to this policy, they will be deterred from harassing and discriminatory behavior. And number two, even if it happens and there's an investigation, such as by the Equal Employment Opportunity Commission, you can show them that you have this policy, which they will give you credit for, and show that you took reasonable steps to prevent discrimination and harassment. There should also be a corresponding policy relating to employees with disabilities that says not only do you prohibit discrimination against them, but you will recognize requests for accommodation. Employees who have disabilities have the right to request accommodations if that will help them perform their job. So you need to have a policy about that, and you need to make sure that you recognize requests for accommodation. An employee says, hey, I've been having some back problems and I'm having a hard time lifting. That is a request for accommodation. And under the law, you have a duty to look into that, and if reasonable, excuse them from those lifting requirements. So you want to have a policy to that effect. The tip here is, in your employee handbook, include those policies, the anti-discrimination policies. In addition, you'll want to conduct training, and ideally periodic training. This again will help provide you with a defense. It will deter harassment And if you can show the EEOC that you do periodic training, that will look even better in the event of an investigation. So that covers the materials. I know it's kind of just a quick overview, but those are some of the critical policies that you'll want to have with your for your employees. And so I'm going to close out, if I can figure out, I'm going to stop my share, and I believe Kat and Greg may be collecting some questions.
Yeah, we have some questions. Kat, do you have anything? Otherwise, I'll go ahead and ask questions.
Go for it.
Okay. Chris, thank you for that. I think the one thing that occurred to me is these tests of employee versus independent contractor. I think in the real world, they're more aspirational than, that bright line. And most of the situations I see have been in the gray areas. And so, for example, to say you can't exert any control over someone, well, in reality, you do exert control even over independent contractors. You might say, don't come here today, even though you don't set their hours, and that's control, right? So if I could just throw out some scenarios and just get your reaction. So we'll call this sort of lightning round thing. So I'm not looking for any detailed legal analysis, but kind of your sense of things. And that might help the audience kind of gauge the levels of risk. So clearly, so let's just start with the restaurant starting up, and they have waiters and waitresses who are independent contractors. What do you think?
That's going to be very hard to establish independent contractor because they're operating a core business, and you're going to obviously be controlling their duties and their hours.
Okay. I thought I'd throw you a softball for.
All right.
How about a restaurant that has delivery service drivers that are independent contractors?
Ooh, okay. Well, I think, again, for the purpose of the ABC test, it starts to get a little gray because is it in the regular course of your business to be delivering food? I think there is a risk they will be deemed an employee because if your course of business is determined to be the service of food, then the delivery thereof could be deemed, in the course of your business. In addition, there may be some control elements, right? I mean, you're telling them, all right, the food's ready for pickup, and so you're going to have to go and drop off the food.
Okay, this is supposed to be called. This is called a lightning round.
All right.
Okay, so we got your feedback there. So it's
all right. Okay.
I guess
risky.
If you were the business, would you do it?
I would treat them because of the severity of the penalties. Okay. I would treat them. It's not worth saving some money on payroll. Payroll.
So that's not gray enough for you. Okay.
Correct.
How about just going down my list here? How about real estate agents who are independent contractors for a real estate brokerage?
I think it's actually pretty common in the industry that a lot of them are contractors.
Right. But is it right?
It's gonna depend upon the particular facts, right? So to just say real estate broker is going to be a little
because they're definitely within the same business as the employer, right?
Yeah. Right.
And right. I guess you said relying on is it in the same region or location? That's a hard one to prove. So anyway, I'm just pointing out that there's some gray areas in the world.
Yeah, I see that. I think the rationale for that one, for the ABC test, is that they're outside the course, outside the premises would have to be the argument. But even then,
you could argue that their premises includes their car, right? Because they got to drive around. How about Uber?
Or any territory, yeah.
How about Uber drivers? Any reaction to that? They're independent contractors.
They are treated as independent contractors. There's probably litigation going around in various jurisdictions on that. So the core of the business is to provide that driving service. So I think, from a technical standpoint, there is risk there. And again, this takes into account, is the Department of Labor going to be actually investigating, right?
But Uber decided to take that risk as a business matter, I guess, because they're not dumb, right? They knew what they were doing.
That and the fact that in different jurisdictions, the tests are going to be different. Hawaii is probably pretty strict in the ABC test.
Okay, moving on to the next lightning bolt here. We have a question in the chat, but I think it relates to my next scenario. How about stylists that rent a chair and they're independent contractors? They're under the same roof, they do the same work, they look like everyone else, but they're independent contractors. Yep. Is it okay or too risky?
I've seen those cases come up, and I understand it's somewhat common to treat them as independent contractors. We've had a case where the Department of Labor came after the company and insisted that they were employees under those particular facts, meaning, you know, their scope of business is consistent with what the company overall is doing, and they're doing it sort of in the premises of the company. So there is some risk. The Department of Labor may not come after every employer, but there is some risk technically.
Is there also an element, as a practical matter, if everyone else is doing it, at least I'm with other, you know, misery loves company, right? So, you know, that, hey, you know, it seems to be the custom, so I'll just go with that. Is there some aspect to that that makes business sense to think about it?
From a business standpoint, yeah, I think you're obviously looking at what your costs are, right? Because you do incur costs by treating them as employees versus the risk, and perhaps sort of running with a pack, maybe there's less risk of a particular audit. But if any one individual makes a complaint, then, you know, then you're going to be on the Department of Labor's radar. But
Okay.
as a practical matter, yeah, I mean, if everyone's doing it, maybe there's less likely, you know, you're less likely to be on the Department of Labor's radar.
So some of you have posted other scenarios, I think similar to what we're discussing. You know, they're independent contractors that are doing totally different things. Like if I hire yard people, you know, I don't know how to, well, I do know how to do the yard. I just don't want to do it. But, or IT specialists, you know, I think Chris had mentioned that scenario, or even massage therapists probably are similar to the hairstylist example. If you rent a table or rent a space to them.
Yeah.
So if you want to actually repose your question to make sure Chris addresses those scenarios, please post it again. But a general question I had is, you're sitting out in the audience, you're small business, you can't afford Chris Ye just yet. Hopefully, you know, you'll make a lot of money and then you can pay Chris. Where do I do? Like, for example, on the independent contractor versus employee question, who do I call? Like, is there a government hotline? Is there a nonprofit? Is there a government agency? And where do I get handbooks and policies? Is there a website that you can refer people to where they can download? So at least they're close to the ballpark. It could be improved if they hired you, but at least they got something. Do you have any ideas for people?
You know, there are a lot of resources online that are put out. I mean, obviously some are better than others. You could call the Department of Labor, but you want to be careful because, you know, if you disclose who you are or what your business is, it may pique their curiosity. But if you could do it anonymously, you know, don't disclose yourself, you may be able to get some advice from the Department of Labor. There are different divisions like that handle work comp issues or health insurance issues. You can call the Department of Labor. If you go with a staffing agency, because you don't want to deal with the hassle of you know, running payroll and everything, the staffing agencies like an Altris or a ProService give you advice as part of, you know, your retaining of them. And there's also Hawaii Employers Council. I mean, they obviously charge, but, you know, they'll provide you with, I think, unlimited services once you pay their fee.
Yeah, you don't want to trigger an investigation. Sometimes agencies will answer questions on an anonymous basis, though, if they're willing to do that. I know
Or
that
you can have a friend call, yeah.
Yeah, I have a friend who has this problem,
Right.
but I know that a lot of employers, basically, you might ask yourself, well, when is this going to be a problem for anyone? Well, in my experience, and Chris can add to this, it's when you have a disgruntled person that might have been hired as an independent contractor, they go complain, or they go try to collect worker unemployment, and the agency says you're not an employee, and then they investigate you. Is that your experience too?
It is. I mean, there is the theoretical risk of an audit, but I don't see that come up too much like a random audit, especially now with the Department of Labor being so backlogged. I'd say the risk of an audit, just being randomly audited, is very low. I think the scenario is what you just described. An independent contractor loses the work and they file for unemployment. I'd say that is a big part of it. The other is a disgruntled employee who's now bringing employment claims for overtime or failure to provide benefits, or someone suffers an injury. I see there's a chat here. I agree with that. They get injured and now they're saying, hey, I want to make a work comp claim. And you're saying, well, you're not on our work comp policy because you're not an employee. Then they do have the ability to go to the Department of Labor and they can complain about that.
There's a lot of questions about software. I don't think it's a bright line test. If you hire a developer to produce a piece of software for your product or your site, and theoretically you could have done it yourself, but it's let's say it's separately identifiable functionality. It's a piece of software that you just assign them to do. I think you have an argument that I think as a business person, you're going to have to make some business decisions along the way on these points. And that's the main thing I wanted to convey, is that it's not a bright line in the real world.
Yeah, I agree with that. And I think in that particular example, you actually may have an argument that they satisfy the part B of the ABC test because they are outside your premises. If they're working out of their home in Massachusetts or whatever, you may have an argument there that they satisfy that. And I also should note the ABC test is limited to a couple of the Hawaii employment laws. It's not the definitive test for all of these laws. So it's possible that even if you don't meet the ABC test, you could still meet a test for independent contractor status under, say, the work comp or the TDI laws, or under the federal and state wage laws, to show that, we didn't have to provide them with overtime because they were truly a contractor.
Okay, my dog might start barking at me here because I could see he's getting ready to. So sorry about that if that happens. Yeah, Zeus.
There's another question in the chat box about confidentiality agreements. So one of our attendees didn't have one in place, but just made one. They want to have their employees sign it. Do you have any practical tips on the best way of getting them to sign it? What happens if they don't want to sign it? Do they still have to hire them? Any practical guidance you can provide?
Yeah, if this is at the time of hire, then almost always they're willing to sign it because they want the job. But if this is a current employee, you have an argument that you are giving them sufficient consideration by giving them access to additional confidential information. In other words, you have to give them something of value, right? To make it an enforceable agreement, you are giving them something of value because you're giving them access that they previously did not have to confidential information. And if that's the case, you want to describe it. Now, if you want to be really safe and you want to give them something monetary, it doesn't have to be a lot of money, some kind of bonus or anything, some additional benefit, you can describe that as the consideration. And hopefully that will be enough of an incentive for them to sign it. But they do have the right to say, I don't want that bonus. Fine, I don't need the confidential information. And then you're left with a decision of, all right, will I just continue to employ them without a confidentiality agreement, or will I just cut them off from the confidential information, or will I actually threaten to fire them as a kind of a hammer to make them sign it and actually fire them? So those are all options. Obviously, the termination option is pretty severe, and you may lose a really good employee by doing that. So I think as a practical matter, you'll just want to find a way to incentivize and sweeten the pot to get them to voluntarily sign it. And it could be just that, in that particular position, they need access to the confidential information, and you convince them, hey, look, I need you to sign this in order for you to keep doing your job. And, it's not very onerous.
Hey, Chris, is consideration, does it include the ability to keep your job?
So yeah, ongoing at-will employment, that's been the subject of litigation as to whether mere continuing at-will employment is enough. Some courts have said yes, some courts have said no. So if you want to be a little bit more aggressive and you really don't want to offer them anything else, you could simply say, the consideration will be, number one, access to the confidential information, and number two, continued employment. And you have an argument that that's sufficient.
Or you could terminate them and then say that you'll rehire them if they sign it.
You could. I mean, you'll have a bad vibes problem. They probably won't be super stoked about that, but
I guess it depends how important it is.
Right.
If you need to fix something that's pivotal, say to your software company or something, then maybe. Although employees do have duties, right, apart from a confidentiality agreement to their employer. So.
Correct. So there are some duties that exist in the law, even if you don't have a confidentiality agreement. So Hawaii has a trade secret statute. Now the information has to truly qualify as a trade secret. So it has to have economic value, and you have to show that the employer took reasonable steps to maintain confidentiality. But if you can establish it as a trade secret and then the employee is now engaged in misappropriation, such as using it against you or sharing it with their new employer, even if you don't have a confidentiality agreement, you could claim a trade secrets violation and sue them in court.
Okay. Well, thanks everyone. We're a little bit past 11, so I want to close the webinar shortly. Chris has agreed to stay on for a few minutes afterwards, so if you have lingering questions, please feel free to stay on. Thank you so much for coming. We hope to see you next week in support of our law students, and they'll give a overview on a lot of the topics we've discussed during the series. And have a great day, and hopefully we'll see you next time. So for those that want to hold on, we'll just hold on for a few minutes, and feel free to ask your questions. Thank you, everyone.
Hey, Chris, can I follow up with that question that you just answered about the confidentiality agreement and sweetening the pot? If there's only, let's say, a couple employees who don't want to sign it, and you're suggesting to sweeten the deal for them, is that legal? Is that fair? Like that they got a deal sweetener, but then others signed it without because they were totally fine with it?
It is legal because the reason for the difference is not based upon any protected class, right? The reason for the difference is a bunch of people, employees were willing to sign it, and these two were holdouts, so you had to sweeten the pot. That's okay. Sometimes if those two employees who held out happen to be, let's say, the youngest, then someone may say this looks like age discrimination. So it can create the risk of a discrimination perception or claim, even though it's not actually discriminatory. And then you just have to defend it on that basis if a claim were actually made.
I guess you could pay everyone the same consideration, right?
You could also equalize it, right?
Yeah, like after the fact.
Correct, right. And the first 10 that signed it aren't going to complain. They're happy to get this additional thing that they weren't expecting.
Right. And then what about people who want to cross out things in the confidentiality agreement? Like, oh, I don't like this. I don't like that. Cross this out. Edit that.
Yeah, it's up to you whether you want to, how much you want to push back on that, right? You could just say, okay, well, this is as much as we're going to get, and so we'll take it. Keeping in mind that all you can enforce now is the non-crossed out portions. Or you can push back and say, no, you have to sign this whole thing. I mean, implicit in all of this, without you saying it is, or there will be consequences, right? You're going to be disciplined or fired, but you don't want to have to necessarily say that. Hopefully everyone will just kind of eventually understand and go along with it. So it's up to you if you want to push back and say, you're not allowed to cross out, here's the clean version, please sign it.
I see. Thank you.
Yeah, I think you want to start out with a confidentiality agreement that's reasonable, that you've thought through carefully, so that if someone pushes back on something, you have a rationale for it. Because sometimes these forms are overly aggressive to begin with. And so, you'll just want to make sure you feel comfortable with everything in that you would sign it yourself, right?
Yeah, and the pitch is pretty soft, right? It's like, obviously, we have confidential information. It's important to our business. And we're all working together on this to protect this information. So, we're just asking everyone to sign this agreement.
And
if you don't want to come down and say, sign this or you're going to get fired, that's too
You can also explain to them the business reasons for it. For example, if you're a company that's seeking investment or you want to be sold someday, you can explain that these are agreements that the investors expect to see in place. And it's going to be a problem for the business if we don't have this from everybody. So, it's not like just you versus them. There's a business reason for it. Any other questions for Chris while we have him? Okay.
Yeah, I got one real quick one. What about hiring people out of state? I mean, what laws apply there? I know this 3-part test are sort of strange local one, but what about that?
My recollection, and I'm not 100% sure, my recollection is the DLAR, the Department of Labor and Industrial Relations, has a certain way of looking at out-of-state workers, and it may be that under certain circumstances, if they're out of state, they're not covered by these laws. But I'm just not entirely sure about that. I believe it's come up a few times. And I think that the informal opinion that we've gotten from the Department of Labor is if they're out of state, they're not covered. What you might want to do is, again, anonymously call and confirm that. Don't disclose your company if you can avoid it. But I believe that generally that's the opinion that we've gotten in the past for out-of-state workers.
Okay. They're kind of strange laws. All right, appreciate it.
Thank you.
Yeah, employment law can be strange and surprising results sometimes.
And they're not always business friendly, as you can see. I mean, they impose a burden on employers, unfortunately, and it's just a matter of analyzing and deciding on your risk tolerance.
Yeah, Hawaii does try to reach out of state sometimes. I remember Expedia tried to avoid taxation, and I think they ultimately lost in court, because they claimed they weren't in Hawaii, right? So, okay, everyone. So thank you. If the panelists stay on and the team, if everyone can sign off, we're going to just complete our internal planning here. So thanks, everyone, for coming, and we'll see you next time.